Namaste ji, namaste. Welcome to Courtroom. Hope you're doing well. So the following series of lectures was part of our online program for the UPSC law optional. But since we don't teach for that specific subject anymore, I have decided to put all of those lectures from our website on YouTube. So एक मैं पूरी playlist I'll create it, and then you can check it. You can check the links etc. in the comments, in the iCard above etc. And it will really help you in even in your LLM preparation, even in your judiciary preparation and law optional के लिए. So these lectures were specifically created for the law optional. They can also help you for your semester. However, if you're preparing for your LLB entrances, I say skip them because it is too much detail. You'll get confused, and stick to the basics for your LLB entrance. All right, so I'll create I'll put this clip in front of each and every lecture that will be posted on our channel, so that you can check the playlist etc, and it makes sense what is happening with these lectures. All right, so it is a sequence. Try to watch them in a sequence, and hopefully you clear and get very good marks in your optional in the UPSC. Take care, bye. Namaste. So now let us cover out the relation between the President and the Council of Ministers, because this is a key crucial topic and I don't want to waste time on talking about the standard stuff that you already will be knowing. So I'm going to split out this lecture over, let us say, 4 to 5 lectures, because otherwise what is going to happen, this will become very huge to take in at one go. So we're going to split it out. So in the further subsequent lectures, what I'm going to do is I'm going to discuss Article 52 to 78. But the most important thing that we will start from here, as in today's lecture, is the relation between the President and the Council of Ministers, because that is the most important topic for law optional from this subtopic, you can say. So from 58 to 72, we will have an overview of articles. We are going to consider them, and those will be basically fillers in your answer. So if you want to elongate your answer, we're going to talk about those. But specifically, we are going to focus on the relationship between the President and the Council of Ministers. And if the Council of Ministers is so powerful, why do we need the President? And if the President is so powerful, why do we need the Council of Ministers to begin with? All right, so let us start. Alright, so Article 52 to 78 is basically talking about the central executive, and we are going to do one short lecture in which we just have an overview of these articles. Basically, just note down those details, and that you can do pretty much on your own as well. I will also take you through those articles as well. That is primarily more suited for a LLB entrance, but we'll still discuss it again to elongate our answers a bit. Alright, so the central executive comprises of the President and the Council of Ministers, and the Council of Ministers is headed by the Prime Minister. So is the Prime Minister a part of the Council of Ministers? Yes, he's also a minister, but he's the prime most. So just like in your college, there is a CR, correct? So PM is basically the CR, the class representative of the Council of Ministers, who basically is the interactive barrier between the COM and the President. You can say in one sense, don't write this in your answer. This CR bit, this is just for your understanding, this is very informal. So the head of the state and formal executive, who is the head of the state and formal executive? That's obviously the President. All executive action is to be taken in his name. That is what Article 53 clause 1 says. I'm not quoting directly the article because I've kept it reserved for another lecture, as I've already told you. Now, the Constitution, write this down, the Constitution formally vests many functions in the President, but he has no discretion as in on what particular function to discharge, because he's always coupled out with the Council of Ministers. So he's always acting on their advice and barely ever independently. Whenever he acts independently, those are very you can say very rare instances, and those we'll have to mention in the answer. Again, in the subsequent lectures, let us figure out wherever he has some discretion. Otherwise, on his own, he pretty much has very little discretion. So write it down. The Constitution formally vests many functions in the President, but he has no discretion in specific functions to discharge. He acts on ministerial advice. Write this down. He acts on ministerial advice. This is what you need. This is the language that you need for the law optional, right? So the PM and the Council of Ministers is actually the real and effective executive. All right. So if they ask you such a question like, why is the President not the real and effective executive, elaborate or elucidate with case laws or whatever, they want to generally test you that whether you know the structure of polity or the relationship between the president and the council of ministers and why and what and how of this topic. So we're going to cover out that as well. How is the admission to the executive organ affected? So basically, President Saab ka election. Remember, we are a sovereign, socialist, secular, democratic republic. So quote this. Start writing such answers now that since in the preamble there is the word republic, there can be no hereditary monarch in the country. Therefore, a president comes. Basically, a president has to be there. All right. So president will have to be elected as the head of the state. We can't appoint a hereditary monarch just like in the UK because we are a republic, right? So since we are a republic, we need to elect a president, all right? Now, the president is not elected by the people, but by way of indirect election. Now, this is very easy for me to tell you, and this I'm pretty sure that you already know as well by now, even if you are not from a law background. I believe, this is very, very basic stuff which you already will be knowing, most likely. But why is this the case? Why the constitution makers thought about an indirect election and not a direct election? Once we start elaborating or demonstrating to the examiner such stuff, by the way, life becomes, you can say, really beautiful and we get much more marks, all right? So why? Now, the constitution makers, they wanted to emphasize the ministerial character of the executive because actually speaking, president doesn't do much on his own. So ज़्यादातर power or basically the majority of the power, where is it? It's with the council of ministers, right? So they wanted to emphasize the ministerial character and it would have been anomalous. Write the word down, ANOMALOUS. For the president, let us say that if there were a direct election. So what do I mean by indirect election? Remember, you and I are not going ever to the election, to the polling booth and pressing a button ki who will be our president, correct? We always choose our MPs. They amongst from themselves choose ministers who basically then, they have an electoral college. And when we discuss the articles, we're going to discuss the process, etc. That who is going to be our president, correct? Now think about it. Let us say when the president has no real power, wouldn't it be like an ironical situation that he's being directly elected by the people? Who has the actual power? The majority of the power. The ministers that we pretty much are sending to the parliament, right? So it would have been anomalous if the president were elected by adult suffrage, that is by direct voting, and not giving him any real power. तो फिर election कराया ही क्यों था? Directly from the people of India. When there is absolutely no problem, तो जिसके पास power है, जो काम ज़्यादा करेगा, well, those are the ministers, the MPs that we choose, right? So therefore it becomes an anomaly. So therefore the constitution makers emphasize the ministerial character of the executive. The final stamp on every action has to be basically taken in the name of the president, but actually speaking, who is doing the work? The ministers, and those we are actually electing as MPs and then sending them to the parliament, and then they become ministers out of that, all right? And then the cost of the election, the president could have become a power center amongst basically within his own right. If the people were choosing him directly, then he could have said, well, hey, I've come here by the will of the people, you can't really control me, right? So basically, I'll do whatever I want to. So to avoid such a power center situation becoming, the constitution makers didn't give him a direct election, and it did not give parliament to power alone. So basically, see, in this pointer, the last pointer that you're going to mention, that did not give the constitution makers have not given the power to parliament alone. The state legislature is also involved in the electoral college that appoints the president, basically, or that elects the president rather. Because otherwise, whichever party is in the majority in parliament will always appoint a party man, and basically there will be no check on the power of the government. All right, so everybody is in check. So the president is checking the government is checking the president, everyone's checking each other in our political system, right? So wahan pe bhi gadbad ho jati. Now all election disputes, this anytime that you're mentioning or writing an answer on the president or the council of ministers, please write all election disputes relating to the appointment of the president. Article 71 clause 1 says the Supreme Court is going to handle. You can pause the video right now, just have a cursory look at 71 clause 1 if you wish to, or in the subsequent lectures, when we actually take a look at the very quick and very macro look at these provisions, we're going to discuss this any which way again. Now write down this case law, NB Khare versus Election Commission, that's AI 1957. Anytime that you're writing an answer on the president and the election, etc., or the relation between council of ministers, NB Khare versus Election Commission, NBKHARE versus Election Commissioner, AIR 1957, please write it. So AI 1957 is not important. NB Khare versus Election Commission is. So Supreme Court said it will not hear a petition before election process is complete and result is declared. So let us say that anyone has a problem with the election of the president, right? It will not hear a petition before the election process is complete and the result is declared. Why so? Because otherwise then that Article 62 of their mandatory period of 5 years, forget it. Let's not make it overly technical, because otherwise you won't have time to write all of that stuff in your answer. So just write this and then write this. Section 14 of the Presidential and Vice Presidential Elections Act 1952. Only two people can file this petition. Either a candidate, that means the person who is fighting for the post of candidate for the president, or 10 or more electors. All right, so that's basically Article 71 clause 3 के अंदर ये सब बताया हुआ. बट इसके लिए हमने एक अलग लॉ है. Article 71 clause 3 के अंदर we have said that Parliament may make law. So according to that, we enacted this act, that Presidential and Vice Presidential Election Act 1952, और उसके section 14 में दे रखा है. So either a candidate or 10 or more electors can file this petition. So point number one, a person such as you and me, we can't basically be going to the Supreme Court and filing a petition against the president or the election, basically for the election of the president. It is not allowed. So either a candidate who wants to become president has filed his nomination papers, A. B, 10 or more electors outside, basically out of the electoral college that elects the president, only those people. And then in the case law of NB Khare versus Election Commission, that's a 1957 ka case law. Supreme Court has already said not hear petition before the election process is complete and result is declared. Okay, crucial points for your answer. Now let us take a look at 58, qualification for election as president, and how it's different from 102. Okay, so open your Bear Act to 58. Qualification for election as president. A person shall not be eligible for election as president if he holds any office of profit under the government of India or the government of any state, or under any local or any other authority subject to the control of any of the said governments. Alright, I believe कि मुझे इसमें और कुछ ज़्यादा कुछ बोलने की ज़रूरत नहीं है. But compare this with 102, that is disqualification of membership. So we're now talking about an MP. If he holds any office of profit under the government of India or government of any state. Let me just zoom in so that you can see this better. Hopefully it is much more better now. The government of India or government of any state. And when I come to here in 58 clause 2, it says any office of profit under the government of India or the government of any state or under any local or other authority. अब ऐसे अच्छा तो नहीं लगेगा कि let us say a contractor becomes a president who's already has an office of profit under any local authority as well. No, this is much more wider. You can actually skip mentioning this in your answer. I'm just telling this to you for your information, that the ambit of office of profit under 58 is much wider than Article 102. Article 102 that does not mention this, under any local or other authority subject to the control of any other said governments. It only says government of India or government of any state. Why? Because the president is a very dignified post. So it's basically removed a lot of office of profits under any, even the local authority, because otherwise it looks very bad. People of India will never accept कि अरे ये कौन आ गया, ये तो अभी वहाँ पे बुलडोजर चला रहा था उस दिन, right? Okay, jokes aside, this is pretty much comparison between 58 and 102. Let us just zoom out for this so that it becomes better. Okay, now the impeachment clause. Again, when we review the articles, we are going to discuss the impeachment process, and any which way you can pretty much read it on your own as well. I believe it is very simple. But the clause is basically, there is only a very remote possibility to invoke this. Why so? Because see, the president is always acting on the advice of the Council of Ministers, correct? So instead of impeaching the president, you can just remove the Council of Ministers, pass a no confidence motion against them in Lok Sabha, and well, that's job is done. But this is a salutary basically provision. What is a salutary? SALUTARY. This is basically something that is actually, it's like a restriction which is good. It's like a salutary provision. Let us say that you not being allowed to eat more than 100 grams of sugar a day is a very salutary thing. It's a restriction, but it is good, right? So the impeachment की जो provision है हमने डाल क्यों रखी है ऐसा तो, because it's a very cumbersome, it's a very very cumbersome provision. It's a very comprehensive provision. It's not easy to impeach the president, right? But we can always pass a no confidence motion against the COM and that gets the job done. So president remains the same, but pretty much his main organ, the main organ that he relies on, gets cut off. All right. Now, why is this salutary in nature, the impeachment provision? Because the president also has to know that, apart from all the immunities that he enjoys under Article 361, which is coming to that, he can be impeached. So, he can't just do whatever he feels like or whatever, comes to his mind. He can't just do that. This impeachment provision is actually good, right? But rarely will it be ever invoked. Okay. Now, he can be removed or he can be basically impeached for violation of the constitution. That is what is given in the article for impeachment, all right? So that's, I believe, if I'm not mistaken, that's 61. So it's violation of the constitution. That's the only ground based on which you can remove it. And who decides whether the constitution was violated? In this case, the House. So when we discuss the impeachment procedure, it will become more clear, because the impeachment procedure is not going to the Supreme Court, is it? It's only basically being discussed by the houses of parliament, right? So if he violates the constitution, the president, he can be impeached. So in the USA, you can impeach him for high crimes, etc. Basically, that whether he's taken some money from someone, etc., etc. In India, the only ground on which you can impeach the president is violation of constitution. And remember, this does not say misbehavior. It's violation of the constitution. And let us take a close look. Okay, and let's take a close look at Article 361. Protection of President and Governors and Raj Pramukhs. The President or the Governor of Raj Pramukh of a state shall not be answerable to any court, meaning even the Supreme Court can't even come in his way, for the exercise and performance of the powers of the duties of his office, or for any act done or purporting to be done by him in the exercise. You see how comprehensive this is. For any court and any act done or purporting to be done, basically the one that is about to be done or done via some subordinates, in the exercise and performance of those powers and duties. See, this is absolutely comprehensive. No process for the arrest or imprisonment of the president, the governor of a state shall issue from any court during the term of his office. No criminal proceedings whatsoever shall be instituted or constituted against the president or the governor in any court during his term of office. And no civil proceeding in his relief is claimed against the president or the governor of a state shall be instituted during his term of office. So see, he's practically speaking, the post of the president is immune, right? So therefore the impeachment provision is salutary, so that at least he knows कि भैया यहाँ से तो immunity है मेरे पास, but I can be impeached as well, all right? So office of the president is very august. No court can compel him to do anything, to exercise his power or to not exercise his power. No writs can be issued against him. No show cause notices, etc. can be given against him. The only way that he goes is either his tenure ends or he's impeached. Impeachment is very, very rare because he's practically speaking ever performing on the advice of the Council of Ministers, and the Council of Ministers is responsible to the Lok Sabha, and they pretty much, they in all practicality, in all real life, they control the parliament as well. So Council of Ministers to aid and advise of the to aid and advise president. Every time that you're writing an answer on the president and Council of Ministers, never ever forget to quote A, NB Khare versus Election of India as an election commission. Then the central executive is given in part 5, chapter 1, right? And part 5 has how many chapters? It has 5 chapters. Try to recall them from memory so that you can write your answers more beautifully. 74. There is no way on this planet that you will not quote 74 in an answer on the relation between President and Council of Ministers. Okay, Council of Ministers to aid and advise President. There shall be a Council of Ministers, compulsory body hai, not even the President can dismiss them. Has to be there at all times, alright? और अभी इसके ऊपर case law भी आ रहा है. The Prime Minister at the head Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in exercise of his functions, act in accordance with such advice. Let us take a close look at photo number 3. 42nd Amendment say they made the President binding, basically bound to the advice given to him by the Council of Ministers. So, for example, let us say the President refuses to follow their advice. Then for violation of the constitution, impeachment proceedings can be initiated, right? So see how much, how much he's dependent on the council of ministers. Basically impeachment का clause ही सरकारों ने इसलिए डाला हुआ है, right? अच्छा जी. Provided that the president may require the council of ministers to reconsider such advice, either generally or otherwise, and the president shall act in accordance with the advice tendered after such reconsideration. So that is the 44th Amendment. I believe that if you mention 42nd and how the advice is binding and how the Council of Ministers is headed by the Prime Minister, and all of this is given in Article 74, I believe that is more than sufficient for your answer. Okay. The question whether any, and if so, what advice was tendered by the ministers to the president shall not be inquired into any court, and this is a very popular question in the law optional. Let us discuss that. But before that, 75. The Prime Minister shall be appointed by the President. In fact, let us stop on 75. Abhi aage aate hain. I've just put it in here so that it's on your screen. When we discuss all the provisions from 52 to 78, let us discuss that. There shall be a Council of Ministers. Now, at no time can the President dispense with this body. They remain in office even when Lok Sabha is dissolved. Write down the case law, UNR Rao versus Indira Gandhi, 1971. So in this case, the main contention was that why does a president need, a council of ministers after the Lok Sabha is dissolved? I mean, what exactly is happening here? He can just work on some of his advisors and then wait for the new body of the ministers to come in. But the Supreme Court said, no. If 74 is saying there shall be a council of ministers, we are going to read the word shall as shall only. It is compulsory in nature to have such a body. The president cannot dispense with it at any time, all right? So write down this case law, quote it alongside Article 74, will make into a very, very beautiful answer and will be fetching a hell lot of marks, all right? Now, the executive power of the union, shall be vested in the president bolne ke liye, shall be vested in the president, shall exercised by him either directly. What does directly mean? Directly means through the council of ministers, or it can be via one minister. Yes, but the council of ministers will have collective responsibility over that advice as well. All right, do you get that? It's directly means it's obviously acting on the advice of the council of ministers. But can one minister advise him and can he take action? Yes. So the council of ministers will basically be collectively responsible for such advice. And the most important case law, sometimes what is going to happen is that you may just forget to quote UNR Rao versus Indira Gandhi 1971. You may just forget to quote NB Khare versus Election Commissioner. But there is no way on the planet that you will forget to quote SR Bomay. इसके मतलब ये case law नहीं छूटेगा आपसे. In this answer, there is no way on that you are writing this answer without quoting SR Bomay. Write this down, okay? SR Bomay versus Union of India 1994, 74 clause 2. The question whether any and if so what advice was tendered by ministers to the president shall not be inquired in by any court. This is what the court elaborated on. And what did they say about this? Let us go to that page. So it was held that no court is concerned about what advice. We don't care. Because anyway, that advice is protected by 74 clause 2, is it not? We are only concerned with the validity of the order. Obviously, now let us say the COM advises the president. And the president passes an order, basically passes an act, whatever he does, he passes an ordinance. If that, we are only concerned whether that order is basically valid. It is not ultra biased to the constitution. That is not beyond the powers of the constitution, all right? So an order cannot be challenged based on that the advice was not followed or no advice was given, right? उसके लिए क्या करेंगे आप? If advice के ऊपर basically जो लड़ाई है, that is between the ministers and the president, we really don't care. The courts don't care. Courts only are concerned about the validity of the orders, right? अगर आपकी वहाँ पे लड़ाई हो गई, if ministers want to impeach him, yeah, well, go ahead, right? We don't care. But if order is challenged, the council of ministers needs to justify the same as to why this this advice was given. So basically, we can't ask you what advice was given. That is completely protected. But you please produce the material based on which you formed the advice that you gave to the president. You produce the material in the code of law. That is the Supreme Court. Now, hang on. You will have to disclose the material based on which the Council of Ministers had tendered the advice. The court is not, it's not, basically the court does not care whether any discussion happened on that material. The court does not care about the contents of the discussion between the ministers and the president. The court does not care whether that actual material was placed before the president also before giving him the advice. So the court is only wants to consider the material based on which the advice was formed. So there are two stages. There is material based on which advice is formed, and advice, this is protected, but this is not. So the court can ask the Council of Ministers to submit before it the material based on which it tendered such advice to the president. Okay. Now, write this down as well. If you can mention this, if you can manage to remember this, well, great. Section 123 in the Indian Evidence Act says, evidence as to affairs of state. No one shall be permitted to give any evidence derived from unpublished official records relating to any affairs of state, except with the permission of the officer at the head of the department concerned, who shall give or withhold such permission as he thinks fit. पूरा का पूरा section वेक्शन कुछ नहीं लिखना है एग्जाम में, सिर्फ ये लिखना है section 123 evidence as to affairs of state. कुछ और वो भी क्यों लिखना है? Because having said that the court can actually ask you to produce material, the ministers or the Council of Ministers can invoke section 123 of the Indian Evidence Act, and that invocation or that basically attraction of this section will depend from case to case and facts and circumstances of each case. ठीक है जी, तो 123 is available, material आप disclose करा सकते हैं, but उस material को अभी भी आप छुपा सकते हैं using 123, and that is open to you. Now the court may allow it, may not allow it, that depends on the facts and circumstances of the case. So SR Bommai में आपने मटेरियल के बारे में बात बतानी है, and then section 123 if you manage to remember it, तो ये आपने बात बतानी है. Then you're going to emphasize or elaborate upon how the constitution makers wanted to emphasize on the ministerial character, basically the powers that are there of the executive. And I believe if you elucidate your answers with such pointers, I believe it will be a very beautiful answer. So in the next one, let us discuss about the appointment of the Prime Minister, and then basically go on and complete this topic in like 4 to 5 lectures. And I believe that we'll be crafting out a very beautiful answer. So SR Bommai 123, NB Khare, UGR Rao. Hopefully it is clear. UGR or UNR? Yeah, I just made a quick edit. I think just made a very silly error. It's UNR Rao, not UGR now. UNR Rao versus IG likha hua, that's Indira Gandhi in 1971. So quote this all whenever you are elucidating the relationship between president and COM, and just tell the examiner that you know how the COM actually has much more power than the president, and how president always acts in advice with the Council of Ministers. Quote Article 74 without fail. All right. Now see you in the next lecture. This is not over. This topic is not over. We have to craft out a decent amount of content and cover out the relationship between the president and the ministers by elucidating a lot more concepts. Well, let's cover it out within 3 to 4 lectures. I believe that will be sufficient enough to tackle this topic. Hopefully you've written the pointers down. All right, now see you in the next one. Take care.